Supra, one of the issues was whether the power under Section 432, 433 of CRPC by the appropriate government would be available even after constitutional power under Articles 72 and 161 by the President and the Governor is exercised, as well as the power exercised by the court under Article 36. Now, dwelling on this issue, it is held by the majority speaking through Honorable Mr. Justice F.M. Ibrahim Khalifullah. Now, if my lord please to skip the part where the Supreme Court, Honorable Supreme Court, just pointing out the relevant portions, Honorable Supreme Court is discussed, my lord. The conclusion which had been drawn, my lord, after considering the fact that what was under consideration in Jagdish was a policy which was there under Article 72 and 161, and not a policy under Section 432 and 433. Now, in the conclusion paragraph, my lord, Honorable Coordinate Bench, my lord, it has observed in paragraph number 8. In view of the principle laid down in which Supra, it is manifestly clear that there exists no vested right in convict to be released by court. The only right is to claim such remission, which, when claimed, would attract the applicability of the provisions in vogue on the date when such claim is made, and not which expressly or by implication are superseded. The provisions in vogue at the time of conviction in our considered documents will definitely be not applicable. So this is what has been held by the coordinate bench in somewhat similar circumstances. There also one of the convictions had taken place, and it had taken place prior to the policy, but the claim was made after the subsequent policy had come. Right. Now, what happened after this judgment, there is another judgment of the coordinate bench, which is WA number dated August 2024. Now, here, the coordinate bench has taken a different view, It has said that it is the date on which the conviction is taken place. So it is both the judgments are by the equal distance bench, If my lord may have this judgment, I just point out the relevant part, Here also the issue was identical.
Bench is same in both.
In page number 5,
Bench is same in both matters.
Yes, but not the same, bench is the Gwalior bench is there, but the constitution is different, or different. So if my may have the page number 6, of this judgment. Paragraph page number 5, paragraph number 7. Heard both parties and produce the report, there is no quarrel with the proposition that the case of convict for premature release or remission would be governed by the policy which stood as on the date of conviction. The proposition on its root in the constitutional bench decision in Manu Sharma versus Union of India. Now, this has been considered by the 1981 judgment, whereas this is a subsequent 5-year decision which has been followed by the earlier. Now, none of this judgment was also not taken note of. Now, what has also happened that in 2024 there is a judgment by Honorable Supreme Court in the case of Bilkis Yaqub Rasool judgment. If my lord may have that judgment also, this is 2024 5 SCC 480. In this, my lord, it is the relevant internal page number is 616, my lord, paragraph number 2224, where it has been, my lord, certain observations have been made regarding which rate will be applicable. This will be, my lord, internal page 136, digital page.
Yes.
Paragraph number 222.4.
Yes.
The policy of remission applicable would therefore be the policy of the state, which is the appropriate government, which has the jurisdiction to consider that application. The policy of remission applicable at the time of conviction could apply, and only if for any reason the said policy cannot be made applicable, a more benevolent policy, if in vogue, could apply. So now this is the third scenario which has come up, where the court is even has not laid down as an absolute proposition that a policy which is prevailing at the time of conviction could apply.
And anything you will write the judgment.
नोट इसमें हमने कुछ और भी साथ में निवेदन किया है। पैरा नंबर 5 पे जाएंगे डब्ल्यू के। इसमें हमने ये मांगा है कि ये जो पॉलिसी इन्होंने इन्वोक करी है, बनाई है, ये इसका कोई विधिक अस्तित्व नहीं। समस्या ये है कि इन्होंने जो बना दी है, इसमें जो प्रेसिडेंशियल असेंट होना चाहिए, स्टेट लेजिस्लेचर अगर सेंट्रल एग्रीमेंट को ओवरराइड करे तो 254 आर्टिकल कॉन्स्टिट्यूशन ऑफ इंडिया उसमें स्पष्ट है कि प्रेसिडेंशियल असेंट होना चाहिए, तभी वह उस स्टेट में लागू हो।
ठीक,
पर इन्होंने इस संबंध में कोई भी असेंट प्राप्त नहीं किया और ये लागू कर दिया।
राइट। थर्ड रिजर्व फुटेज।
But my case something different in my case. My case is WA number 100 of the 27. My first conviction was my lord on 27.
Listen, convictions are before the policy.
Yes, my lord.
Conviction before the policy or after? Conviction. आपकी conviction policy से
99.
policy से पहले की है।
Policy later on.
आप policy letter ये तो हम बोल।
99 का हमारा first conviction.
Right.
27 जनवरी 1999.
Yes, yes.
इसमें हमारे साथ में सर रुपेश सुरेश शिवदेव is the present respondent. The single bench, honorable single bench, passed the order. I have filed with the IE, my lord, at page number 10, my lord. May kindly see the order, my lord. Firstly, they have mislead the honorable court, my lord. May kindly see the para number 2.2 of the memo of appeal filed by the state government. That is against the aforesaid judgment and the finding dated 27/1/99. The requisition respondent has other filed criminal appeal 3/1/1999, 3/16/1999, Honorable High Court dismissed the same on 12/9/2007. The appeal of the writ petitioner respondent was dismissed. Some of other accused also shall be dismissed by the Honorable Supreme Court, but that is not correct. My first conviction was held. Thereafter, I am approached the Honorable Supreme Court. Meantime, my lord, an incident was occurred in 2008. My lord. The state government taken my consent from the jail as per page number, my lord, 55, my lord, of IE, my lord.
Yes.
They have assured the respondent he will be released on 15th of August 2013, my lord. On that assurance, my appeal, which was pending before the Honorable Supreme Court, my lord, withdrawn upon my application, my lord. Thereafter, my lord, they have declined. That is the state appeal.
Second one.
Second one.
Why the state has filed?
State appeal is because the Honorable single bench has considered my case, even though the case which is they are relying, the Union of India versus Syria, that is also considered by the Honorable single bench.
Right.
After that, taking the consideration of the case of the state of Haryana versus Jagdish, my case was considered because I am judicial custody more than 27 years. And my right for premature release was
चलो बिल्कुल
इसमें सर एक चीज और लास्ट बताना चाह रहा हूँ, इसमें जो अदर कन्विक्टेड थे 302 में सजा काट रहे थे, वो भी दूसरे वाले मर्डर केस में दे आर आल्सो कन्विक्टेड बट दे हैव रिलीज्ड देम एज पर डॉक्यूमेंट मैडम annexure RD 13 page number 126. They are also similarly situated case of the present respondent and the case of the person who are released from the jail, that is Bandi Sevak Ram Bharti and Funji Lal. They are also convicted in the subsequent judgment, my lord.
Right.
And the subsequent jail sentence already suspended by the division of bench of the honorable court.
Right. ठीक.
Serial number 47.
My lord, ये संविधान पीठ का निर्णय है इस संबंध में डॉक्टर ऑफ
ले लो ये.
दीपक ने 254 के संबंध में
मैंने इसी में रिप्लाई के साथ ही तीन ऑनरेबल सुप्रीम कोर्ट के रिसेंट जजमेंट फाइल किए हुए
Right. Will करते.
मानो हेलो गाइस
And I believe that 12 companies which are registered to clear
Yes.
record on 14th of December, right, agreed, I have submitted the questions of law have been fundamentally clear. Could we also continue to refer to those questions? I would also see. If I not see, the order should actually be the principle of